All right, so let's dive into Chapter 9, insurance contracts. So pretty much almost every business deals with contract law in one way or another. Insurance companies are no different. They are really beholden to contract law because everything an insurance company does revolves around a promise, and that promise is delivered via a policy, which essentially is the contract. So Chapter 9 is as much about generic contract law as it is about insurance companies. We're going to talk about some of the differences, though, that exist that are specific to insurance companies. So we'll do it in three parts. We'll start with agency law, and then we'll cover the requirements of a contract. That's more of the generic contract law stuff. And then we'll talk about the distinguishing characteristics of insurance contracts. And if we have time and if you have interest, we'll go through some of the discussion questions that help drive some of these points home. So when it comes to agency law, as you know, most insurance policies are not purchased, but they're sold. That's the way they put it, because it usually takes an agent to go out and do the hard work of marketing a policy to get something sold. Insurance companies act as the principal. Insurance companies are like, man, we'd really like to get some policies sold. Insurance companies are good at gathering capital and doing the actuarial work of figuring out which products should be sold, what price should be charged, the underwriting requirements, and then they hire an agency force to go out and sell these products for them. And you could think of this principal-agent relationship a lot like we discussed in estate planning. For those of you that are in or have had estate planning already with me, you know that when you sign a power of attorney agreement to give someone else the authority to make decisions on your behalf, that power of attorney authority is essentially you as the principal giving someone else, the agent, the ability to transact on your behalf. Similarly, an insurance company acts as the principal and says, please go out and do my work for me. Please go out and represent me. And they authorize the agent to enter into contracts. Insurance companies take this very seriously. They should anyways, because when you hire an agent to essentially represent you, you are giving that agent the authority to bind you to deals that you may or may not love. And if the agent binds you to deals that you did not intend for that agent to bind you to, you're probably going to get rid of the agent eventually, because that agent can put you on the line for all sorts of exposures that you may or may not have wanted. So an agent has a lot of authority because you, as the third party, you as the customer who's like, I don't care who's in charge here. All I want to know is that I'm dealing with somebody that has authority. And it's assumed that the agent has authority when they are acting on behalf of the company. So if they have company forms, if they've got signage, if they've got business cards, then you would assume that they're representing the company. Now, it's possible that you've got some fraudster who's never, ever encountered State Farm or American Family in their lives, right? And maybe they've manufactured their own forms, and this is a really elaborate ruse to get you to part with your dollars. But if a person has ever had an agency relationship with an insurance company, either by being directly appointed by the insurance company, or if the insurance company treats that person as an agent, that's what determines whether or not they have the authority. So again, express authority, you're appointed by the insurance company. I worked for State Farm as an agent. They appointed me as an agent. Now, there are other insurance companies that might not have this formal relationship with this other person that becomes an agent, but if they begin to treat them as an agent, then the third party has every right to believe that they have the authority, that the agent has the authority of the principal to act on their behalf. This is a really important concept in insurance because this agent can bind, as I mentioned before, it can bind coverage to a third party and put the principal on the line for those risks. And so this binding authority is interesting because you may or may not have had this happen where maybe you bought a car and your parents were like, oh, hey, you have to call our agent to let them know that we now own this car. And you call up your agent, let's say you're with Allstate, you call your Allstate agent and you're like, hey, we just added this car. I know it's a Saturday. I hope it's okay. Are you able to make sure that we're covered? And that agent will issue a general binder. And that general binder says, yes, you're covered. Even though it's verbal, and even though you haven't even given them any money, we'll talk about this in the next section where the conditions, as part of the conditions of a contractor that there's some sort of consideration. You probably already have auto policies insured with Allstate or else you wouldn't have called your agent. And they want you to rely on them. They want it to make, they want to make it easy to do business with them. So they will allow you to make that call and they will allow, the agent is allowed to issue general binders. Now, and this is really common for auto and homeowners and renters insurance, even boats or recreational vehicles. Now, where it's not so common to get this general binder is in life and health insurance. Insurance companies will often tell the agent, look, you can issue conditional binders for life and health insurance because we are only going to cover that person if our underwriting department says it's okay. So a general binder means the moment that binder is issued, you are covered, no questions asked. Maybe later they'll change the terms of the coverage, but from that time that you get that general binder until the company says otherwise, that coverage is in force. As opposed to a conditional binder, you'll have coverage so long as the underwriter says yes. So a conditional binder does not give you as broad a coverage as a general. So there are two other terms in this chapter that really both apply to the insurance company. Now, it benefits the client, it benefits the third party, but they're important to know. The first is this term waiver. So technically, the legal definition of waiver is intentionally relinquishing a known right. You have to know you have it before you can relinquish it and before it can be a waiver. But in this context, a waiver would occur if an insurer, the insurance company, considers something to be too risky to insure, but the agent knowingly binds coverage anyways. The agent has then waived the insurer's right to deny coverage. So the scenario I put in here, insurer considers drivers with multiple DUIs to be too risky to insure. And maybe they have a policy that they absolutely will not insure someone if they've had more than 4 DUIs. But the agent knows this person, he's friends with them and he can't say no. And so he just goes ahead and he issues a general binder anyways, knowing that that was the case, knowing that that person did not meet the underwriting rules. Well, then that agent, on behalf of the company, has waived their right to deny coverage. That's why the agent is such a critical component in this and why they can really mess things up for an insurance company. Now, waiver differs from estoppel because with estoppel, you are leading the insured to believe that coverage exists. For example, as you know, most homeowners policies exclude earthquake unless it's specifically added as an amendment. So let's say it's a standard insurance policy and the agent is new and he's really eager to be helpful and sound knowledgeable. And the client says, hey, I'm really worried about earthquake damage, even though we live in Wisconsin. I think I've heard that we can have earthquake damage, which is true. I assume my policy covers that. And the agent's like, oh, absolutely, totally covers it. Well, if the policy says it's not covered, the agent has just led the policyholder to believe that coverage exists, therefore it will be enforced. And if the insured can document that discussion, then the agent has stopped the company from denying that coverage exists. So again, having this human being out there representing you, again, just like with a power of attorney for property, that agent can bind you to things that maybe you had no intention of taking on. All right, so let's do a quick quiz on that. Well, actually, these discussion questions, because I've had some requests for these discussion questions to be covered. Number one, describe how agents can bring major liability suits from consumers against their insurers. Do you think insurers should be liable for the actions of their agents? I don't love the way that this question is worded. What it's essentially saying is, how can agents really mess things up for their insurance companies that they work for? What can they do to bring on lawsuits to an insurance company? And in this chapter, you probably recall, if you read it, that there was this whole class action lawsuit about vanishing premiums policies where agents led customers to believe that their life insurance policies would be paid in full after a certain number of years, which was not true. And this created a really expensive situation for insurance companies to clean up. And so that is one example of how an agent can bring major liability suits against their insurance companies, unintentionally bring them. It asks, do you think insurers should be liable for the actions of their agents? What do you think? Do you think it makes sense? Does it make sense that that insurance companies should be liable for the actions of their agents?
Yeah.
Why do you think so, Austin?
Because they give them the what's it called?
Authority?
The authority as agents and representatives.
I mean, we kind of already think that insurance companies, insurance companies have a reputation already, right? Of being like looking for ways to deny claims or deny coverage. And I think that if we are to, if we start suggesting that agents don't represent the company, well, then why have an agent? I guess. Anybody have any other thoughts on that? And if any of you have had an experience with an insurance company that sort of is along these lines where you relied on an agent to do something, I think one of the most interesting situations I dealt with when I was at State Farm were agents that were, either the agent was or their staff people were using policyholder funds for their own benefit. And essentially, ripping off both the company and the policyholder. And there were lots and lots of policies that went out of force, but the agent led the client to believe that they were still in force while the agent was enjoying the use of those premiums. So obviously the company didn't get the premiums. They were still exposed to those risks. And they also usually did not press charges against the agent because they didn't want the bad press. So, that's an extreme example of how an agent is held, that the agent's actions essentially can be detrimental to the company. All right, let's see what the other one was. Let's explain the concepts of waiver and estoppel. I think those are interesting terms, and I gave you two situations. I don't know that additional examples are going to be that helpful, but I would encourage you to make sure that you understand the difference between waiver and estoppel. And then Henrietta Hefner lives in northern Minnesota. She uses a wood-burning stove to heat her home. Although she has taken several steps to ensure the safety of her stove, she does not tell her insurance agent about it because she knows that most wood-burning stoves represent uninsurable hazards. Explain to Ms. Hefner why she should tell her insurance agent about the stove. Well, this is an interesting one because really in the next section, we're going to hear about this doctrine of utmost good faith, which states that we rely on utmost honesty when completing an application for insurance. And we would expect Ms. Hefner to tell us about that damn stove because she knows it's, well, first of all, it's probably one of the application questions. And if it's not, and she conceals this wood burning stove, knowing that it would be an important piece of information, she would risk having coverage be denied. Now, if she tells her agent about the wood burning stove, and let's say the company is absolutely opposed to insuring homes with wood burning stoves, but the agent insures her anyways, what has the agent committed? Is it waiver or estoppel? If the agent knows about that wood burning stove and insures her anyways, issues a binder anyways, is it waiver or estoppel? Rachel? Waiver? You're right. Because the agent, the company is like, look, there is no coverage for this. The agent knew that the company's underwriting policy was like, no wood burning stoves. But the agent still issues a binder that is waiver. All right. Quick quiz. True or false? Conditional binder secures coverage for an insured without any additional input from the insurer. True or false? Oops. I'll take chat responses too if you'd rather not take off your microphone. True or false? Conditional binder secures coverage for an insured without any additional input from the insurer. Exactly. Because a conditional binder requires an underwriter to say yes. Which of the following binder is commonly used in the property and casualty insurance areas? A secure binder, promotional binder, general binder, or conditional binder? Again, commonly used for property and casualty insurance. How about via chat? Let's get an answer. How about in the room? Anyone? General, correct. A general binder is what we rely on our agents to give us. We're like, look, don't give me a hassle here. That's the whole point of why I'm paying extra premiums to have a human being be my intermediary instead of dealing with an online insurance company, right? Give me a general binder, make sure I'm covered no matter what. I just did that one. If an insurer considers a risk to be undesirable at the time the agent assumes it on behalf of the company, and the agent knows it, the principal will have waived the right to refuse coverage at a later date. Is that true or false? Andrew, what do you think? Is that true or false? Can you guys online hear me okay?
Yeah, yeah.
Yeah. Fair enough. Thanks for the confirmation. So if an insurer considers the risk to be undesirable at the time the agent assumes it on behalf of the company, much like this fire, what did I just call that thing? Like a wood burning stove, right? If the agent knows the company doesn't want that risk, but the agent still binds the coverage, will the principal have waived the right to refuse coverage at a later date? Yes, that is true. Okay. And which of the following best explains the intentional relinquishment of a known right? Yes, waiver. Thank you. Awesome. Thanks. Okay. This, we didn't talk tons about it, but the vexing problem of vanishing premiums has proven to be an expensive lesson for insurance companies on, and I'll just tell you which one it is, the doctrine of respondent superior. So it's essentially just saying that the principal is responsible for the actions taken by the agent. So it's part of it's the downside of having an agency marketing system. You know, there's some lots of benefits to it, obviously. If it wasn't that helpful, we would have gotten rid of it, but it does create some issues for insurance companies. Okay, so let's move on to the next section, which really just walks through the requirements of any contract. We'll apply it to insurance contracts, but all contracts require offer and acceptance. So if any of you have been involved or aware of like a negotiation to purchase a home, you know, when a home is up for sale, you write an offer and then the seller can either accept it or write a counter offer, which completely negates your initial offer, right? So a contract includes both of these elements. And when it comes to an insurance contract, the insured is the buyer and the one that makes the offer. The insurance company either accepts or declines. Now, it may feel a little bit wacky to look at it that way because you're like, I don't know, you usually have an agent that's pushing you to like consider purchasing it. You almost feel like you're the one who's accepting it, but that's not true. It's the insurance company that decides whether or not to accept it. And sometimes the agent is making that decision as the intermediary for the insurance company. There's also consideration, which typically you think of consideration as the price that you pay. So in the case of an insurance contract, it might be the premium, but it's not always the premium. Sometimes it's the conditions of the contract that act as consideration. You know, for example, when you call up your agent and say, hey, bind coverage on my new ATV, the terms of the contract spell out the expectation that you'll continue to make your monthly premium payments, that you are telling the truth about this risk that's being added. The other element that seems like a no-brainer, but competent parties, that the person who is purchasing the insurance is competent. One of the examples that's given in the book is, you know, is a minor considered a competent party? You know, can minors enter into a contract? Well, it depends on the state. Some states will allow you to purchase auto insurance if you're under 18. Others will not. They'll require that you have a parent involved. But generally, when we're talking about competent parties, we're talking about people who have the mental wherewithal to enter into an agreement. And of course, the contract has to be for a legal purpose. You know, if you're entering into a contract to commit arson, that's not legal. And then it has to be on legal form. And in the insurance industry, we've got lots of legal forms, and they have to follow suit with what that state's laws require. So all of these elements exist within an insurance agreement. This one. Following the construction of a storage shed on his property, a homeowner refuses to pay the builder the full amount agreed upon, the full amount that they agreed upon orally for performance of the service. Can the builder sue the homeowner and collect damages for breach of contract? Why or why not? Now, keep in mind, this is obviously not an insurance contract. We're just talking about a generic contract. But if that were you, if you were the contractor that had just built this storage shed and the homeowner refused to pay you after agreeing on this, should you be able to sue the homeowner and collect damages for breach of contract? What do you think? What would it depend on?
Would there need to be documentation of the price?
Say that one more time, Austin.
Would there need to be documentation of the agreed upon contractor price?
Yeah, so is there any, yeah, is it questionable with the amount that they agreed? You know, one of the things that comes up often with contractors is some of them will give you a firm bid for the job, and some of them work on what's called time and materials. And, you know, maybe you thought you got a firm bid from the contractor, or maybe as the contractor, you're like, hey, I thought I told you it was going to be about $1,000, but it took me longer because you made so many changes. And so now it's 2,000. So yeah, I think that that would be part of it. In general, though, if there was some agreement that there would be payment, you could absolutely sue and possibly collect damages for breach of contract. But this doesn't really, I mean, it's not specific to insurance. And I think maybe some of these quiz questions will help drive some of these home. I'm going to skip those that I don't think. Oh, there's only 4. See, the section's pretty straightforward. So to a contract must have a legal purpose. That is, it must not be for the performance of an activity prohibited by law. That's pretty simple. In the making of insurance contracts, the insurer usually offers to sell and the buyer accepts or rejects the offer. Is that true or false? Think back to what we talked about in the very beginning of this section. How weird it is, because you think when you're the insured, you're the one that's accepting or rejecting whether or not you're interested in the insurance, but that's not actually how it goes. Yeah, it's false. The buyer is the one that offers to buy, and the insurer says whether or not they accept or reject the offer. The value of consideration is usually unimportant, but lack of consideration will generally cause the contract to be regarded as a gift. But remember that consideration isn't always money. It could be some other condition. All right, let's move on to the distinguishing characteristics of insurance contracts. The concept of utmost good faith we already discussed. And the history of insurance takes you back to when ships were carrying cargo back in God knows when, and people were trying to make a living shipping things in a very dangerous situation and wanting to purchase insurance on their loads that were being shipped. And so insurance companies couldn't like physically go inspect these ships to make sure they were in good shape. And so they had to take the customer at their word that the ship was in good shape. And they would issue the policy knowing that if there was a loss, the insurance company was going to go back and make sure that that ship was in decent shape. So this whole concept of utmost good faith really just states that you as the insured are held to the highest standard of truthfulness. When you complete an application for insurance, it's a pretty serious set of questions that are being asked. That is not the time to be coy. That is where you want to be very frank about what's going on. It can be kind of embarrassing, especially if you're completing an application for life insurance or health insurance. There are even some embarrassing things about maybe your driving record, but you've got to be honest when completing these applications, because if you are not, it's possible that coverage could be denied and the policy canceled if it's discovered that you misrepresented yourself, or if you just left out something that was material, or if you concealed it. So some examples of material facts that might change an insurance company's decision to offer coverage might be your age. It's actually technically, when it comes to life insurance, if you lie about your age, oftentimes what they'll do is they will just change the amount of life insurance coverage you would have had they known what your age was. But a material misrepresentation, maybe age is a bad one. What if they ask, have you ever had cancer? And you say, no, but you really have. Or if they ask about your family history and you're like, nope, everybody's fine, but it turns out you lost a parent early due to heart disease or something. Those would be considered material facts. Same thing like with a wood burning stove. If the agent asks you, how do you heat your house? And you say gas, because maybe you do have gas, but you generally use a wood burning stove, that would be a material fact. And if you fail to represent that, the policy might be canceled once they learn it. The book gives the example of concealment. We already talked about the wood burning stove, but the funny one in the book was, if your neighbor's house is on fire and you call a company to quickly insure your own home, maybe you didn't have coverage, or maybe you didn't have renter's insurance. And you're like, oh crap, now I need renter's insurance because the place next door to me is burning. Well, if you fail to tell the agent that your next door neighbor is on fire while you are applying for coverage, that would be considered concealment. So those all fall under this whole idea of utmost good faith. We expect you to be honest when you are completing an application so that we can adequately evaluate you as a risk and adequately price you as a risk. Now, once the policy is issued, note that it's a contract of adhesion. What we mean by this is that you don't negotiate anything when you are the insured. You take the contract they give you. It's not like you can redline a bunch of things, right? Like as a financial advisor, I've occasionally had people look at my contract and like want to strike certain portions of it, which I don't accept. I'm like, I just don't want to do business with you then, but I could, if I wanted to, I suppose, modify my agreement. But as an insurance company, you don't get that choice. You don't get to modify, especially for a personal insurance policy. Maybe if you're a big business and you want to negotiate some of the details, that's possible. But for most of us, average Joes, we are going to get the policy as it's written, which means that it is a contract of adhesion. We adhere to the contract that the insurance company gives us. But there's a huge benefit to this. Because we don't participate in the design of that contract, we get the benefit as the insureds as the customers, that if it's gray, it's paid. We used to use this statement all the time when I was in claims, because if there's any area of the policy that's at all questionable, it's like, wait a minute, that's confusing. The benefit goes to the customer. There's also this expectations principle that essentially says that if it's reasonable for the insured to expect coverage for this thing, whatever it is, even if the policy specifically says it's not covered, there's a very good chance that a judge would say, it's covered, if it's reasonable to expect that coverage would exist. So having these contracts be contracts of adhesion really benefit the insured. The next section deals with this principle of indemnity. And the word indemnity essentially means to make whole. And indemnity, this concept of indemnity or to make whole, is also why insurance settlements are not taxable. If you receive an insurance settlement for a, let's say you're in a car accident and you get rear-ended and you have a sore neck and you miss time from work and you're inconvenienced and the insurance company settles for $15,000. That $15,000 settlement to you to settle your injury claim is tax-free because we've just made you whole. We are indemnifying you. We're putting you back in the position you were in before the accident happened. That's an important concept for insurance because we need things to be, we don't want insurance settlements to be a gain. We don't want people to be incentivized to file insurance claims, which you might be going, of course they're incentivized to file insurance claims. People love to file insurance claims. They make money at it all the time. Well, they might think they're getting ahead by filing an insurance claim, but the idea is you are not supposed to be getting ahead by filing an insurance claim. Like today, did anybody see any hail? There was hail a little bit on the west side of town. And so what happens whenever it hails outside? Have you ever heard somebody say, quick, take your car out of the garage? Get it outside quick so it gets hit by hail? Well, it's true. People do it all the time. And they do it because they love hail damage, because hail damage is super expensive to fix, but you can drive around with a hail damaged car. And if you don't care the way your car looks, you can get a settlement from your insurance company for the cost to repair the hail. Now, of course, you won't get it fixed. You're going to put that money in your pocket. And so if it gets damaged again, you're not going to get paid again, at least not for similar damage. But that's an example where maybe it's a little bit questionable whether or not you were indemnified. But the idea here is that if you were to try to sell your car with hail damage, you're going to experience a loss. Maybe before the hail damage, it was worth $10,000. And now after hail damage, it's worth $7,000. So some insurance companies will try to take that approach in settling your hail damage claim with you in the event that you're not going to get it fixed. But the idea here is being, you shouldn't be getting ahead as a result of filing the claim. And in order to even purchase insurance, you have to have an insurable interest. An insurable interest means that you personally would be financially affected by the loss. An insurable interest in a home would be you own the home, or you're the mortgage company that loaned money for the home. Or for an auto policy, you own the auto. And in the event that there was a loss, that you'd be financially harmed. And when it comes to property and casualty insurance, like for home and auto, you have to have the insurable interest both when you buy and at the time of a claim. You know, I could not, for example, let's say I watched my neighbor fall asleep with, you know, lit candles all the time. And I'm like, that Yahoo is going to burn his house down. I should buy an insurance policy on his house so that I get paid when his house burns down. Well, that you can't do that. I don't have an insurable interest. I, of course, want to make sure my own home is insured so that his carelessness doesn't hurt me. But I would not have an insurable interest unless I owned the home and owned the auto. And that insurable interest would have to continue even at the time of claim. So let's say I sell my house, I insure it, but then I sell it and I don't cancel my homeowner's policy, and the new owners have the house burns down to the ground. Even if my policy is still in force, I don't have an insurable interest any longer in that house. Therefore, no claim would be paid. So when it comes to home and auto, you've got to have an insurable interest both at the time of purchase of the coverage and at the time of a claim. Now, what's weird is if we're talking about life insurance, and you think about an insurable interest for life insurance, you have to have an insurable interest at the time of purchase only. You do not need to have an insurable interest at the time of the claim. And there are
Go look at his phone case.
Well, I don't know how many people are left, but it's continuing to be recorded, so hopefully it'll be recorded in 2 pieces and I'll splice them together. All right. Can you guys hear me now? Mind hitting them in the chat box to see if they can hear me? I don't know how many people are left online.
Yeah, they said they can hear you, but your screen isn't sharing.
Okay, thank you. Okay. So viatical settlements aside, moving on to this concept of subrogation. So we've talked about insurable interest. Moving on to subrogation. Subrogation is just simply the insurance company's ability to collect from a third party for any damages they paid on your behalf. So let's say you get rear-ended and you're like, man, I did not want to get rear-ended today. And the person that rear-ends you, let's say you've got State Farm, and the person that rear-ends you has American Family. And you love your State Farm agent and you're like, look, I don't want to deal with American Family, even though they're 100% at fault. I'll just let you, State Farm, take care of my damage because I've got collision coverage. So I use my own collision policy. I have a $500 deductible, fine, I'll pay that. But then State Farm is going to subrogate for the damage they pay out to my car. And they're gonna go after, they're also gonna go after American Family for my deductible. So they're gonna subrogate against AmFam. For the damage. Same thing if you have let's say you are, you have a renter's policy. Right now, you're living in an apartment and you've got all sorts of expensive stuff in your apartment that gets completely damaged as a result of smoke from a fire that started next door. Your neighbor's burning a pork chop at midnight. almost takes the whole building down, but destroys all of your stuff. Your renter's policy that you have is going to pay for your damage to your stuff. It's also going to pay for you to live somewhere else for a while. And that they're going to go after your neighbor and your neighbor's liability coverage to get that money back, as well as to get back your deductible. That's subrogation. So it's just essentially the moment you have your own insurance company pay your claim, if they can go against somebody else to go get their money back, they absolutely can. You have signed over your ability to do that. So you can't collect from both. Whenever you have a health insurance claim, let's say you go to the doctor and you're like, oh, I hurt my shoulder. They're going to ask you, was this something that happened at work? Because your health insurance company will subrogate against your employer if your injury is due to work. So that's subrogation. There's also this concept of paying actual cash value for a loss versus replacement cost. Going back to your renter's policy. If you have an inexpensive renter's policy and you didn't want to pay for the extra coverage, you might have what's called an actual cash value policy, which means if your couch that's in your apartment that got damaged was 10 years old, then when we go to replace it, they, being the insurance company, is going to give you the value of a new couch minus the 10 years worth of depreciation. If you have replacement cost coverage, they will just go ahead and buy you a new couch. Essentially the same kind of couch you had before. They're not going to make it leather if it wasn't, but you can pay extra to get replacement cost coverage. Technically, again, going back to this idea of indemnity, replacement cost coverage can put you in a slightly better position than you were in before the accident happened. There's also this other insurance clause that is buried in most policies that says, look, if you have two insurance policies for the same loss, you can't collect from both. We will pay in proportion to the amount of coverage that we had. So if you insured your renters, maybe you have $50,000 worth of personal property coverage on your renter's policy from both American Family and from Allstate, and you have any loss, they're each going to pay for half, because they each represent 50% of your total coverage that's out there. And then the last concept that's specific to insurance is this idea that your coverage is personal. They're insuring you. So you might have an auto policy that you bought coverage for, but they underwrote you as much as the car. And when you sell that car, you're not selling the policy with it. They got to get their own coverage, because the insurance company is insuring you because your behavior drives more likelihood about the odds of a risk than the car itself. So it's personal coverage. It's being underwritten based on you. Okay. Per usual, I went longer than I expected to. But let's go through the quiz for this last section real quick. Oh, it's going to make me log in. One moment. Okay. In property insurance, insurable interest is required only at the inception of the contract. Is that true or false? Oops. If you guys online can hear me, what do you think? True or false? In property insurance, insurable interest is required only at the inception of the contract. Correct. False. It's required at both. Viatical settlement companies buy life insurance policies from persons with short life expectancies. True or false? True. That's correct. The book, make a note of this. If you do this quiz in the future, I'll check. Maybe they fixed it, but I told them this one was wrong. Most property insurance contracts are considered to be valued policies. No, they are not. Have they fixed it yet? No, they haven't. Most property insurance contracts are not valued policies. Life insurance contracts are valued policies where they will pay the stated amount. The death benefit is $100,000. They're not going to make sure that your life was worth $100,000. It's like, we're just going to pay you $100,000. That was the value of the contract. Most property insurance contracts, we don't state a value up front. I mean, there are limits, but it's not as if we promise like right out of the gate that we're going to pay X no matter what. Which of the following gives the insurer whatever claim against third parties the insured may have as a result of the loss for which the insurer was paid? Horrible sentence, but essentially, which of these terms describes the right the insurer has to go after the at-fault party if they pay for claims on your behalf? Subrogation. Which of these describes the settlement where there's no deduction for depreciation? Replacement cost. Actual cash value refers to the settlement where depreciation is taken. Replacement cost is, we'll just pay you whatever it costs to replace what you had. Insurance contracts insure against the person's property, not against loss to a person. It's the last thing that we talked about. It's false. Even though you buy an auto policy, it's the human that incurs the financial loss. We insure the human and their insurable interest in that property. I'm going to skip over this one because I don't like the fact that they did not use the exact terms. This should be utmost good faith, not ultimate good faith. But I will not test you on the Latin. Representations are made for the purpose of inducing insurers to provide insurance. That is true. Customers make representations, or potential prospective customers make representations with the goal of getting the insurance company to issue the policy. Insurance policies are contracts of adhesion. Which of the following best explains this statement? In the event of a dispute, courts will read insurance policies as they would expect the insured to do. No, that's not quite right. Insurer agrees to pay no more and no less than the actual loss suffered by the insured. That's actually describing indemnity. Insureds have no input in the design of a policy's terms. Well, that sounds more like it. Let's read the last one. Potential insureds are held to the highest standards of truthfulness and honesty. That's the doctrine of utmost good faith. So contracts of adhesion happen when you have no input in the design of it. Which of the following holds that in the event of a dispute, courts will read insurance policies as they would expect the insured to do? It's the expectations principle. And then which of the following prohibits the insureds from deliberately causing loss of their property to gain from the insurance on that property? Well, it's not Latin. So it brings it down to one of two. What do you think? Yes, contracts of indemnity. It puts you back in the position you were in before the loss occurred to make you whole, so that you don't gain. And then the law concerning insurable interest is important to the buyer of insurance because it determines whether the benefit from an insurance policy will be collectible. Is that true or false? That is totally true. I mean, you know, if you thought you were being clever, you know, just like they were with, we read in a previous chapter about credit default swaps. You know, credit default swaps were so awesome for the people that created them because they're like, hey, we can profit from somebody else failing to make payment, even though we personally don't have any insurable interest. It wasn't a true insurance contract. It was a financial deal they made. So when it comes to insurance, we need there to be an insurable interest. And when you're purchasing the coverage, you need to know whether or not you're going to get paid out and what the definition of insurable interest is. So with auto and home, you have to have an insurable interest both at the time of the contract and at the time of the claim. With life insurance, you only need to have an insurable interest when it's originally purchased. Going back to my crazy neighbor who leaves his candles burning all night, I might think that would be really smart for me to buy life insurance on that guy, right? Because he gonna die. Now, I don't really have an insurable interest because I'm not relying on him financially. I don't have a relationship with him. So I technically couldn't buy life insurance on him. But if he bought life insurance on himself and then offered to gift me his policy for whatever reason and make me the owner and he stays the insured, I took it. That's fine. I don't need to have an insurable interest when he dies in order to collect the claim, just when I take it out. All right.